In this video, we're going to answer some of the most commonly asked questions regarding the transition from H-1B or any other work visa to a marriage adjustment of status.
Let's imagine you are in the US working and you meet a person you fall in love with. You guys make a decision to get married and proceed with a marriage green card. If that sounds like you and you're just starting to look into this process, you're likely not even sure where to start. And I'm sure you are also wondering how this transition will impact your current situation. In this video, we'll go over some of the most important things to know and to consider.
And just so you know, this channel is for marriage immigration self-filers just like us. After going through our own marriage immigration journey, we became lawyers and created this channel to provide the support we wish we had.
So be sure to subscribe and click the bell so you're not left in the dark to figure this all out on your own.
And don't forget to grab your free access to our new mini course, where we completely break down all the different marriage green card immigration options.
You can download it completely for free at the link below in the description.
Now, we receive a lot of questions from immigrant couples wanting to adjust status through marriage from a work visa.
Now, knowing how this adjustment process will proceed from your work visa is very important, so you're not constantly stressed out about whether you're risking your employment, and instead you're able to focus on other important things in your life, such as your newly formed marriage.
Alright, so you're here on an H-1B or any work visa for that matter, and now you're about to get married, or you are married, and it's time to apply for a marriage adjustment of status. So let's start with question number 1.
Will a pending marriage green card application affect your current status? Obviously, the question is, am I jeopardizing my current work visa by submitting this marriage application?
The answer is no. The USCIS will treat the H-1B and marriage green card as two separate processes and statuses which are unrelated. And when it comes to H-1B, even a rejection of a marriage green card application will not affect your H-1B status.
Another question we often get is there a difference if a work visa holder marries a US citizen versus legal permanent resident?
And yes, there is a difference. Let's start with a scenario where you're married to a US citizen. In this case, the US citizen spouse files an I-130 petition and supplemental I-130A form with the USCIS on behalf of their foreign spouse. With this petition, the US citizen is officially asking the government to recognize the bona fide marriage between the two spouses, which will be the basis for a grant of an IR1 or family-based visa.
And then from there, the foreign spouse files a marriage green card application or Form I-485 to ask the government for legal permanent residency based on their IR1 visa. The good news is that because there is no yearly limit on the number of IR1 visas the government can grant, as it is in the immediate relative visa category, the USCIS allows you to perform both steps simultaneously and file the Form I-130 and I-485 together, which is called concurrent filing. This allows both requests to be processed at the same time, which shortens the application timeline considerably.
Now, if you're married to a legal permanent resident, there are some nuances to this process. You would still file Forms I-130 and I-485 in this case, but you now need to look at the visa bulletin. The April 2023 visa bulletin saw a drastic change to the F2A family-based category, which is spouses and unmarried children under age 21 of green card holders.
Due to an overwhelming number of cases in this category, the final action dates for these applications have lost their current status for the first time in years, since 2019, I believe. Final action dates pertain to applications that have reached the front of the line and can now be processed.
Although still able to file, you won't be able to move forward with your green card application until the priority date is current. This change is likely to bring about increased wait times for green cards under the F2A category. This makes it all the more imperative for an H-1B holder married to an LPR to file their marriage green card as soon as possible, as there is always a looming danger that the process may drag on past the H-1B holder's 6-year time visa limit to remain inside the United States.
And with the difference between marrying a US citizen or a green card holder, drop a comment letting us know which is your situation. Either way, you will want to really pay attention to the details of this journey to successfully navigate it with the least amount of delay, complications, and stress.
Now, unfortunately, due to massive tech industry layoffs we've been seeing recently, the next question we often get is, can I begin the marriage green card process if I have lost my H-1B status? You can if you're married to a US citizen, but you can't if you're married to a green card holder.
If you're married to a US citizen and your H-1B status has already expired, you can still file for a marriage green card. This is because the US immigration law allows immediate relatives of US citizens, meaning spouses, minor children, and parents, to adjust to permanent residency by filing Form I-485, even if their status has expired.
Keep in mind that this rule does not apply if you have left the United States after being in unlawful presence for more than 180 days in the country, or if you have entered the US illegally in the past.
When it comes to spouses of green card holders, you cannot obtain a marriage green card inside the US if you fail to keep a valid status when you file Form I-485. However, you may be eligible to obtain a marriage green card outside of the United States through consular processing if you accrued unlawful presence in the US for less than 180 days before leaving the United States.
Another important question we always get has to do with work permits. Again, it's that transition period that couples are often unsure about. So can you apply for an EAD card based on your marriage green card application, even though you have a valid H-1B status? What happens if you use that EAD? You have the option to file for work authorization, Form I-765, alongside Form I-45. This will grant you an EAD card, which is a separate work authorization from the one you received with your H-1B.
Filing for and obtaining an EAD card does not by itself affect your H-1B status, and it is often a good precautionary measure to have in case you lose your H-1B work authorization during the long application process, especially if you have already or if you are near the 6-year limit. In this case, you would be able to use your EAD work authorization once your H-1B work authorization expires. And it's generally a good idea to apply since it takes the USCIS a long time to process work authorization documents.
But here's an important nuance. If you use your EAD work authorization while you're still on your H-1B status, for instance, for a second part-time job, then you automatically terminate your H-1B status. This really doesn't make too much sense, but that's the way it is, so be mindful of that.
And by the way, the exact same thing applies to advance parole or travel permit. Filing for and obtaining advance parole does not by itself affect your H-1B status, and again, it is often a good precautionary measure to have in case your H-1B travel authorization expires during this long process. But if you use your advance parole while you are still on H-1B status, for example, you leave the United States and come back as parolee, you automatically terminate your H-1B status.
Another important question we get is how long will it take to transition from a work visa to a marriage green card if applying from inside the United States? For spouses of US citizens, it will take anywhere from 6 months, but can sometimes take up to 2 years.
For spouses of green card holders, it will be a much longer wait because of the recent change to Visa Bulletin. However, if your LPR spouse becomes a US citizen during your application process, you will be moved up in the visa categories from an F2A, which often has long wait times, to an IR1 visa, which is immediate. This may save you months or even years of waiting during this application period.
Just know that as soon as the naturalization occurs, you must send the USCIS a letter and supporting documentation regarding your spouse's naturalization in order to implement your visa category change.
You have questions about this process and you want to make sure you're not messing up your current employment while properly applying for your marriage green card. But what if you had all of the answers from day one and could get help when you need it?
That's exactly what members of our marriage immigration method receive. No guessing, no wasting time on research or reaching out to random people for questions. Just getting through this process as easy and frictionless as possible.
If this feels right to you, then we encourage you to apply to our method. All the details and links are in the description below, and we look forward to chatting with you.
Please give us a quick thumbs up and subscribe if you like this video. It really helps our channel and helps other immigrant couples who are looking for answers to their questions.
Otherwise, we will see you next week with our new video.